employment, any kind of legal updates that may be relevant at this time. Currently, there's a few updates which either come into effect this month or in the near future, or obviously have already just come into effect, which I will be discussing today. On my own today, normally I try and get a guest on, or someone with a bit of legal knowledge which I would not be able to assist with, but today I'm on my own. If you guys have any questions, please either ring the studio on 01902 972 150 or WhatsApp your messages on 074 404 20432. That number I'll repeat again. To WhatsApp your text messages are 07 440 420 432. Right, so what I'll do is I'll start off with some immigration updates, and then I'll move on to planning law. There's been a few planning law updates as of this month, so may be relevant to anyone who's either building a house, building an extension, or is planning on doing so. So with the immigration, one of the updates that I have for you is that if you intend to leave the UK, if this is obviously for people who are on visas, if you intend to leave the UK but have not been able to do so, and you have a visa or leave that expires between 1st of September and 31st of October 2020, you may request additional time to stay, which is also known as exceptional assurance, by contacting the Coronavirus Immigration Team, CIT. If you are granted exceptional assurance, it will act as a short-term protection against any adverse action or consequences after your leave has expired. Exceptional assurance does not grant you leave. So basically, to put that plainly, is if your visa is expiring and you can't, for instance, get a plane back, obviously there's issues with flights, etc. at the moment, you can apply for this exceptional assurance, which will give you some time to arrange these flights and arrange to return to your home country. So after you've completed the form, it's obviously an application form that will need filling in. You'll be told that you'll need to submit to show you can't leave the UK. So as I've discussed, you need to give evidence of why you can't leave the UK. For example, if you can't leave the UK because you can't find a flight before you leave or visa expires, you'll need to submit a copy of a confirmed flight ticket. If you can't leave the UK because you have coronavirus, you'll have to submit confirmation of your positive coronavirus test result. So it's not as simple as just filling the form. Yeah, we'll get a bit of a leeway. You need to provide evidence of this. So if you've already completed the form to request exceptional assurance, you do not need to contact the Home Office again. They will consider all requests and will get in touch with you to inform you of the outcome. And during that time, so between the period when you've submitted this application form and any contact that you have, you will not be treated as an overstayer. So your leave will still be valid, and any rights that come with that leave for when you will be the same as when you were on the actual visa and entered the United Kingdom or had the extension for your visa, etc. And it won't have any detrimental. You won't suffer any detriment in any future applications. So So that's one thing. And another thing I would like to address as far as immigration law is concerned is so if your leave was to expire on the 31st of August, just gone, 31st of August 2020, you can apply, you can submit an application form from within the United Kingdom where you would usually need to apply for a visa from your home country. So, as you know, a lot of applications, even down to, for instance, if you've got married in the UK, generally they would say, no, you have to return to your home country and submit an application from there. Or if you were in the UK on a visit visa and you'd normally have to return, submit a fresh application if you want to return again and return back to the UK again. All these applications now for this during this coronavirus, COVID-19 period, can be submitted from within the UK, which is, sorry, I just realized I hadn't transitioned on the Facebook. So yeah, this can be done from within the UK, which is very useful and helpful for a lot of families. For instance, as I mentioned just a couple of minutes ago, if they have applied to, if they've got married and they'll save on costs, not having to travel back to their home country, whether it's one of the Asian countries, Pakistan, India, Bangladesh, or any other country, and they won't have to return there. They can submit applications there, which is useful. Normally, the only way they would entertain such applications would be on human rights, and that would generally be if you have links with the UK which you can't leave, i.e. children. But coronavirus has changed the thought process of the Home Office, that currently the need exists for laws to be amended. Not saying that they will stay. Obviously, as soon as we're all back to normality as we know it, or as close as normality as we know it, I'm sure the Home Office will be looking to go back to their norms. So, yeah. So on this, with these applications, you'll need to show your application is urgent. For example, if you need to start a new job or course for study, you need to provide details of this and covering letters and supporting documents of that. So yeah, it affects students as well. I didn't mention students before. So students who would normally have to travel back to their home country to reapply, they can apply from within the country as well. So you need to pay the fees and meet all the requirements of the visa as normal. However, there's no free time here. They still want to make you pay. So the only difference being you having to submit it from here. And this is still under review. So it will be kept under review. So as and when they feel that they need to go back to the norms, they will. There's no set date. So the other point, moving on, is if you overstayed your leave, if your visa or leave expired between January 24th and the 31st of August, there will be no future adverse immigration consequences if you didn't make an application to regularize your stay during this period. However, if you did not apply for an exceptional assurance by 31st of August, you must make arrangements to leave the UK. So, again, they are trying to facilitate people's leave based on what effects coronavirus has had on society as a whole. Now, I want to move on now. I read a little article this morning, in fact, on LinkedIn. Um, there's a well-known immigration barrister um, who generally um, puts up quite a few updates. And he, in fact, I'll see if I can get him on any of my future shows. Um, Now, he's put an article up. I'll go through the article for you guys now. Again, very helpful. The Home Office have included coronavirus concessions at the end of a number of their key policy documents. So, an extract from the current version of the Home Office's Immigration Directorate Instruction Family Migration Appendix FM. So, Appendix FM affects families really. Um, Now, this, I don't know, whenever someone is listening to the show, obviously this is for now, current for now. This was published in August 2020. So versions amend regularly. So, please take this as in August/September 2020. Now, this sets out the approach caseworkers must take when deciding a case to ensure applicants are not disadvantaged as a result of circumstances beyond their control because of COVID-19. Now, in these instructions, there's on page 69 to be exact of the instructions, it states income received via the coronavirus job retention scheme or the coronavirus self-employment income support scheme can count as employment or self-employment income where there is evidence of a temporary loss of income due to COVID-19 during the period 1st of March 2020 and 31st of August 2020. You will apply the following concessions. So this is advice that the Home Office is giving to their caseworkers who are actually assessing these immigration cases. A temporary loss of employment income between 1st of March and 31st of August due to COVID-19 will be disregarded provided the minimum income requirement was met at the required level for at least 6 months up to the 1st of March 2020. So, as before COVID-19, if you applied for, a spouse visa, you'd have to provide 6 months wage slips, 6 months bank statements, and make sure that in those 6 months you could prove that your income for the year should amount to 18,600. So what the Home Office is now saying is because of COVID-19 and people being furloughed, etc., this threshold does not have to be met per se. As long as it was met before March, if up to March you had the full amount for the last 6 months, during March, if you are receiving a lesser figure, i.e. are on furlough and receiving 80%, they will disregard that. They will say, okay, that's fine. It still counts as the full amount, as long as it's the proper furlough figure. Now, I'll move on in this article. So it says, an applicant or sponsor furloughed under the government's coronavirus job retention scheme will be deemed as earning 100% of their salary. A temporary loss of annual income due to COVID-19 between 1st of March 2020 and 31st of August 2020 will generally be disregarded for self-employment income, along with the impact of employment income from the same period for future applications. Evidential flexibility may be applied where an applicant or sponsor experiences difficulty assessing specified evidence due to COVID-19 restrictions. So what you would have to do, or your lawyers would have to do, is they should rely upon this policy when making an application for entry clearance. Now, leave to remain or indefinite leave to remain applications under the family immigration rules where an applicant's or sponsor's income has been affected by the pandemic. So, yeah, so it can be done for indefinite as well. You could you could use this for indefinite applications also, as long as you have genuinely been furloughed and your income has reduced by the furlough amount and due to furlough. So yeah, that's a great point, I believe, and great article by this barrister to update us all on how things are. Now, guys, moving on. That was all my immigration updates for today. I don't believe there's anything else I can mention about current immigration law. If you have any questions, please feel free to contact the studio, either by WhatsApp message or by telephone. There are some updates that I will say for another show. That are updates which will come into effect once we are out of the European Union. So once Brexit has concluded, which is end of this year, there are new guidelines and guidance there which shows what those European countries, so visitors or people want to come and study, people want to come and work from those European countries, what they would have to satisfy, what rules they would have to satisfy. So I'll try and cover that in a later show. Guys, seeing as I don't have anyone to speak to in this studio, and we will be moving on to the planning reforms. Any questions? Call the studio on 01902 972 150, please, or you can obviously WhatsApp us on 07 440 420 432. I welcome any questions. Right, moving on. Now, buildings and property market is booming at the moment, and people will be looking to either move or build extensions, etc. Either to add value to the properties, or sometimes it's cheaper and more cost effective to just build an extension to accommodate whatever needs to be accommodated. You had another baby maybe and you want another room. Sometimes it's easier to build an extension and to facilitate that, rather than sell up and move to another property. And builders that I've been speaking to are saying, they don't have time at the moment. It's so busy. And one of the reasons for this, I believe, could be that the COVID-19 planning reforms. So just before the pandemic outbreak, the government issued the trailer Planning for the Future, announcing various proposed reforms to the planning system. This was to be followed by a white paper in the spring, but following lockdown, obviously lockdown has affected a lot of things, the white paper was postponed. So instead, the government concentrated on emergency measures to alleviate the crisis. Obviously, they have to think, well, how do we get around this? What's the best way forward? So what they have thought, as lockdown eased, Boris Johnson has launched a Project Speed aimed at getting Britain building again, including a radical reform of the planning system. Now, this has resulted in a flurry of legislation with more to come. So this is only the start. So there's many more legislation that would be updated and changed and brought in, which will affect the way the building industry works, the way the planning works. So earlier on in the week, I spoke to a architect. So I had a discussion with an architect. In fact, the plan was to get this architect on the show and have this discussion with him. That couldn't happen due to his prior commitments, but instead, what we did was we sat down and we went through a few questions. I made notes on that, and so I think I have about 10 questions here, which might be useful to some people. So I have the questions and I have his answers. The answers are be brief, but hopefully they'd be useful to you guys. So let's start with the first question. So it relates to time extensions for planning permissions. So I said the question I asked was if my planning permission is due to expire or has just expired, what do I need to do to keep my permission from lapsing? What many of you guys may or may not know is that generally, once you have planning permission, you have a certain timescale to start the work. If the work is not started in that certain timescale, it you would have to apply for planning again. So you may even have seen in places where someone's got planning permission and then started digging the foundations, dug the foundations and maybe filled in the foundations of a property or an extension and then left it. The reason that could have happened is because they were possibly coming to the end of their planning permission and then decided, well, unless the work started, this permission is void. So it's better to get it started and then therefore it won't lapse. Anyhow, so I've asked this question. So what do I need to do to keep my permission from lapsing? The answer that he gave me was simply nothing. He quoted some law. I tell you what, I wasn't going to bore you with the actual sections, but go on, I will do. So, pursuant to Section 17 of the Business and Planning Act 2020, there is an automatic extension of time in which to implement a planning permission until 1st of May 2021. So, obviously, this is a new act of this year. There's been a lot of new legislation coming this year, all due to COVID-19. So, this being one of them. So, this automatic extension relates to all full planning permissions granted subject to a planning condition to start work between 19th of August. This is when Section 17 takes effect, and 31st of December 2020. So if your work was due to start between these dates, so as I said before, there's a certain timescale. So if the timescale said that your work must start between 19th of August and 31st of December 2020, then you have this automatic extension till the 1st of May 2021. Great initiative by the government here, I believe. Obviously, there'd be a lot of people who would be struggling to either find the builders or even start the work, or there'd be other restrictions which they can't deal with until COVID-19 has been dealt with, or until things are taking longer. Generally, things are taking longer. There may be even people who, for instance, are buying a property with planning permission on it and thinking, oh, I need to get this over the line by such and such date to make sure the planning permission is still valid. In such cases, again, there's a lot of law firms who are working from home and things are taking longer. Property, conveyancing is booming at the moment as well. So generally, lawyers are overworked, and therefore, that's one of the reasons things are taking longer also. So an extension till the 31st of May 2021 is much welcomed by all, I suppose, anyone who's in the building trade and anyone who's looking to have an extension. or build. So we're about to go into a break. May I remind people that I'm here for the next another half hour. If you have any questions, please either call the studio on 01902 972 150 or WhatsApp your messages to 07 440 420 432. Thank you. Assalamu alaikum. Welcome back after the break. My name is Yaz Ali. I'm here with the Legal Clinic. Thank you for listening to me and the Ramadan Radio Wolverhampton team. We are here every week, really, trying to help in the community and see what we can guide you, assist you with. just before my show, obviously there's a very entertaining news of the week show, which I like to listen into. Very informative sometimes, and you learn something new from them every week. Um, right. As I was mentioning before going into the break, so initially I mentioned some updates. I updated on a few immigration um, related matters. What is going on now? What you need to do if you're in certain situations, and yeah, moving on from that, we went on to planning reforms. So COVID-19 and the latest planning reforms as of this month. Um, so I covered one question, which, as I mentioned before the break, I had a meeting with a architect. So with an architect, and he could not make the show today. However, I still wanted to go ahead with the show with this topic because it's so current, because it now comes into force now. Pardon me. I wanted to make sure that you know I updated you guys on something that's fresh. So I went through a few questions with him, and I have uh, put them down on paper, and I'd like to go through them with you. So, hopefully this can help some of us. Um, First question I've just covered just before the break, which was, do I need planning permission if my permission has lapsed recently or is about to lapse? The answer to that is no. Um, as mentioned before, no. There's been an extension, which has an automatic extension of time in which to implement a planning permission, which is until the 1st of May 2021. So this affects anyone who had a planning condition to start the work between 19th of August and the 31st of December of this year. So moving on, the next question that I posed to Sean was, so planning permission for our new block of flats. So this will affect any developers who are looking to build a block of flats, which is flats are going up everywhere at the moment. New block of flats. So planning permission for our new block of flats expired during lockdown on 6th of June 2020. Before we could commence work, is there a way of still being able to lawfully start work? So a very similar question to the previous question. However, A, it's a new build, a block of flats, and B, the dates are different. So the answer to that is yes. Unimplemented planning permissions with time limits for implementation that expired between the 23rd of March 2020 and the 19th of August 2020 are capable of being extended to the 1st of May 2021. So they can be extended to the same date as the applications which where there's a condition to start the work on between 19th of August and 31st of December. However, so subject to additional environmental approval being granted. So yes, if an application has expired between 21st of March 2020 and 19th of August 2020, yes, it can still have take advantage of the extension to the 31st of May, to the 1st of May 2021. However, an additional environmental approval needs to be sought. Now, in order to secure additional environmental approval, or AEA for short, an application will need to be made in writing and submitted electronically to the council. So each council obviously has their own way of working, but the general rule is that the application must be submitted electronically This will need to provide the information specified within the 2020 Act, but there is no prescribed form for the AEA application. So yes, again, good news that if you couldn't build your block of flats or whatever you were building in that period, you still can take advantage. Yes, there's a bit more running around, I suppose. There's a bit more form filling, but it is possible. You're not going to lose out. You're not going to lose out on time per se by having to reapply for a new application, and costs, of course. What hasn't been said is the cost. What is the cost of the AEA? Maybe I should have asked that question, but I'm sure it won't be a great amount. In the grand scheme of things, especially if someone's building a block of flats, I'm sure a couple of £100 they won't miss. So, yeah, I'll move on to the next question. And as I mentioned earlier, if you want to have a quick chat on any legal topic which you need advice on or guidance on, please give me a ring on 01902 972 150, or you're welcome to WhatsApp me. I think it's a bit quiet this morning on the WhatsApp messages. Sunday, well, this afternoon I should say. This Sunday seems to be people must be still sleeping. So WhatsApp is 07440 420 432. So moving on to the next question, so outline planning consent was granted a few years ago, but the reserved matters were due to be approved by 1st of April 2020. And since we had gone into lockdown, the time period for their approval has now expired. Can we take advantage of the time extension under the 2020 Act? As you can see, I've had to think long and hard for these questions. Again, the answer is yes. So even though outline permission was granted a few years ago, there is advantage still can be taken of the extension. So yeah, his reply was, as the time limit extending implementation operates in exactly the same way as for full planning permissions. This means that the time for implementation is extended until 1st of May 2020, but an application for additional 2021, I would say, but an application for additional environmental approval will need to be made since the expiry date was before 19th of August 2020. So yeah, those can still take people in such positions, such predicaments can take advantage of the same extensions. But again, as I said, there's certain other criteria that they would have to meet also. So next was, do the time extensions to commence work extend to listed building consents? See, listed building consents are quite different normally to normal planning permission consent, because obviously if it's a listed building, there may be other issues that need to be addressed other than just planning permission. The answer again is yes. All listed building consents with a time limit requiring implementation between 23rd of March 2020 and 31st of December 2020 will benefit from an automatic extension until the 1st of May 2021. There is no need for any application to be made for additional environmental approval. So whereas the last couple of questions there was a need for additional environmental approval, for listed building consent there will not be. So the same rules would apply, the same extensions will apply and will be given without the need for the extra application for additional environmental approval. Right. Now I'll move on to extensions, upward extensions. So permitted development rights for upward extensions. To say I'm a freeholder of a block of flats, and so is it right that I can now add two more stories under permitted development rights? If so, what do I need to do? Interesting one this is. So his response was, perhaps from 1st of August 2020, it was possible to rely on the provisions under the Town and Country uh, planning permitted development and miscellaneous amendments England coronavirus regulations 2020 to carry out works to construct up to two additional stories of new flats immediately above the topmost residential story of a block of flats. However, there are a number of limitations on when and how such permitted development rights can be exercised. For example, the existing block of flats must have been built between 1st of July 1948 and 5th of March 2018, and the extended building would be more than 30 meters high, excluding plant. Various buildings are also expressly excluded, such as those listed or within a conservation area. So obviously conservation area, they have their own rules and regulations again which need to be met. In order to rely on the new permitted development rights, it's necessary to first apply for prior approval. There is a prescribed list of matters that need prior approval, including issues such as transport, external appearance, and light, both to the new units as well as the impact on adjoining properties. So, yeah, these matters would need to be addressed. So, they will take into account the appearance, issues of transport, i.e., is there good transport links? Would you need more parking? Would there be sufficient parking on site or around the site? If it's in a town, sometimes you have you don't have to provide parking because the councils feel maybe the transport links are such that people may be able to use those links rather than keeping vehicles. But all of this would need to be taken into account. Also, the light. So, would there be sufficient light? Would it affect anyone's light? All these things will need to be taken into account if you are to be building these extra stories. So, moving on to residential, normal residential. So, can I build a residential extension on top of a commercial building that my company owns? Again, the answer is perhaps. So this has come into effect as of the 31st of August 2020, the new act which I'm referring to. This introduces a new class double A. Before I came here, I'm sure my son was talking about double A, but he was talking about batteries. A new class double A, which allows for the construction of up to two new stories of flats on top of detached buildings in commercial or mixed use, which are commercial or mixed use. If your building is not detached, a new class AB permits the construction of new flats on top of terraced buildings, including semi-detached buildings in commercial or mixed use, including residential use. There are, however, a number of restrictions and conditions relating to reliance on the new permitted development rights, including the need for prior approval from the council. So it is permitted development, but obviously there are approvals which may be needed before you carry out any work. Um, so yeah, there seems to be a lot of emphasis by the government to try and build more flats. Most of the last questions, as you can see, are relating to flats. So there seems to be an emphasis on flats, probably because it's quicker and maybe cheaper to build flats than houses, and obviously it takes up less room, so more people can be accommodated. However, what I have noticed currently, people who have lived in flats over the previous 6 months during lockdown now want to either move to houses or move to, for instance, if they're on the second or third floor. One of my clients, in fact, I was on the phone to last week, said they are currently living, elderly couple, they're currently living on the second floor or third floor, I'm not entirely sure, in a block of flats. But they are looking to now buy a flat on the ground floor. I said, oh, interesting. Is it for investment? No. They want to move to that ground floor purely because that comes with some garden space. So a lot of people have suffered during lockdown with not having that space to get out and get some fresh air, in their own space, in their own bubble space, as opposed to having to go and walk, across the streets or parks, etc. So yeah, but there still seems to be an emphasis on flats. So, do the new permitted development rights for upward extensions include private residential dwellings? Answer to that was yes. The number 2 order allows for the enlargement of existing dwellings for either A, up to 2 additional stories, where the existing dwelling consists of 2 or more stories, or B, 1 additional story, where the existing dwelling is 1 story. There are various restrictions relating to the new rights, and prior approval is required from the council. So although it's permitted development, you still need to contact the council. You still need to make sure that you have the right approvals in place. Pardon me. But again, if it's a 1-story building, you are likely to get permission for another story, and same as if it's a 2-story building, you may get permission of 2 more stories. So it's worth looking into. So the use class changes. I believe we have 4 minutes left. About 2 or 3 questions left. So if we occupy several retail units within a town centre, I understand the use classes have changed to allow more flexibility in changes of use that would suit us. Is that correct? Answer is correct. The Town and Country Planning Act, I will call it, will come into effect, or is now in effect. At the time it was coming into effect on the 1st of September, but it's now in effect. This creates a new broad category of commercial business and service uses, Class E, which will allow greater flexibility for change between these 3 types of use, with the aim of assisting with the rejuvenation of high streets and town centres. For transitional purposes, the regulations provide for the existing range of permitted development rights for changes of use in the GDPO to be preserved until 31st of July 2021. Individual buildings and uses will be able to exercise the permitted development rights they were entitled to as of 31st of August 2020. So what I made of this was that it'll be much easier to get change of use in the high streets, in town centres. Previously, it was quite difficult, especially when councils wanted to retain certain properties or certain number of properties as certain uses. Uh, Maybe that was so as not to flood the high streets with one type of use. For instance, you could go down certain high streets and all the properties would be, there'd be 7, 8 restaurants. But then council started bringing in conditions and restricting the number of restaurants in a high street. So yeah. So moving on. So question was, I'm thinking of buying a vacant office building near me that I would like to convert to flats. The original building was quite small, so I would like to build something larger. Can I rely on the new permitted development rights to do this? Answer to that, partly yes. Again, the same act takes effect as of 31st of August 2020 and introduces a new class ZA. This allows for the demolition of a single detached building in existence on 12th of March 2020 that was used for office, research and development or industrial processes, or a freestanding purpose-built block of flats to be demolished and replaced by an individual detached block of flats or a single detached dwelling house. However, the new building must be within the footprint of the original building with a maximum footprint of 1,000 square meters and no higher than 18 meters. It is also worth noting that the original building must have been built before 1990 and have been vacant for at least 6 months before the date of application for approval. Guys, hopefully this would have been of use to you guys. I do have a couple more questions, but I only had 10 seconds left, so I will love you and leave you and look forward to being back. Thank you very much. Allah Hafiz.